Everybody, thank you for joining us today for AshBer's May webinar. My name is Amber Hines and I'm the owner of AshBer. We specialize in short-term Medicaid compliant annuities as well as longer-term annuities and helping clients to basically spend down assets in order to become eligible for benefits. Today, I'm super excited to introduce attorney Todd Whatley. He is a certified elder law attorney. He primarily practices in the state of Arkansas, but he also has a coaching business. And today he's going to be talking about when to use a Medicaid Asset Protection Trust and when not to, which seems to be a highly popular topic based on the number of people that are here. So without further ado, I'll go ahead and introduce you, Todd. You can take it away.
All right. Thanks, Amber. Hey guys, good morning, and I'm Todd Whatley. Yeah, this is something that is one of my issues that I find very interesting, that coaching clients and just attorneys across the country, when they learn about this trust, are like, oh my God, this is the best thing ever. This is, yeah, everybody can use this, and this is just going to transform my practice. Well, hopefully it can transform your practice, but what I am seeing is people are using it inappropriately. Now, it's a fantastic tool. I love it. I use it when it's appropriate, and when it's appropriate, it is perfect. But I see a lot of people using this that is going to cause some issues in the near future. And so if you know me very well, you know that I've never worked in a big firm. I've really never worked as an attorney for anyone else. I've always been on my own. I've learned this stuff on my own, and I do it the way that I think is best, not how someone taught me. And so you will learn that my approach is a little different than most people. All right, there we go. So the problem with the modern MAPT teaching, what people are being taught or what they discover, is that everyone should have an MAPT, okay? Put all of the assets into the irrevocable trust and they'll now be protected, all right? It protects everything from the nursing home, yeah, and it's the gold standard for Medicaid planning. All of those things are incorrect, all right? So the reality is MAPTs aren't universal, okay? They are beautiful, beautiful tools when used appropriately, okay? So they are powerful and they are very useful. They are strategic in the right situations. And I'm gonna go through these pretty clearly, when these are good and when they are not. But they are sometimes absolutely the wrong tool. So just a little background on me. I owned a farm back in the past and some things happened and I had to sell it, COVID mainly. And then we moved back to town. I was bored to death. And now we have recently purchased another 30 acres. I love it. I love working out there. I love doing things, and having the right tool is amazing. I just built a chicken coop, okay? If you want to see my chickens, email me and I'll let you see them. But I built this thing, you know, it's pretty big, got a long run, and it's really nice. And I got a new screwdriver, electric screwdriver, and man, I can, you know, do some stuff, but the screwdriver is not good for nails, okay? You don't want to slam nails in with the screwdriver. The tool is the right tool when you use it appropriately, and it's an amazing tool when it's used correctly. So an MAPT is not a default elder law document. Okay, it is a specialized planning tool for specific fact patterns, okay? Now, my objectives today, number one is I want you to recognize the proper MAPT scenarios. When does this work? When does this do a fantastic job? I want you to learn when an MAPT fits and when it does not. Understand the downsides. There are some huge downsides to this. Just like with any other tool, you have to understand the tax, the control, the practical issues with an MAPT many times make it so that it is not the right tool. And we can discuss alternatives. Okay, Todd, if the MAPT is not the right thing, what else can we do? Okay, I will go over that. So if you don't know, I'm assuming that you probably do know what an MAPT is, but it is a Medicaid Asset Protection Trust. It's an irrevocable trust where the grantor does not control and many times has zero benefit, okay? It removes assets from the Medicaid countable resources. So once you do this trust, you put assets into the trust, and then Medicaid says, okay, they're gone. That was a gift. They're gone outside of your control. It does start a 5-year look back, and this is where people get in trouble. They either don't understand or they don't appreciate or they've just never lived through this to understand that 5-year look back can be devastating. And then finally, what's interesting and the selling point of this to clients is it keeps assets in the estate for tax purposes. And so I forget how many years ago, it was quite a few years ago, the tax court or Supreme Court, someone came out and said irrevocable trust are, when you have an irrevocable trust, you do not have a step up in basis. And a lot of people in the elder law world, particularly my coaching clients, were freaked. They're like, oh my God, Todd, I've done this for people. What's the problem? And I started getting phone calls, and that was the topic of many of our coaching calls there for about 3 months. And the research was, it doesn't affect us. That's if the grantor does not retain the benefit from that trust. If it is not a grantor trust, yes, you will lose your step up in basis, but these trusts are designed to be a grantor trust so that the IRS says, yep, you still own it. And it's really interesting when you can tell a client, look, I charge a lot of money for this trust because it does some really amazing things. But here's what it does, client, is it tells Medicaid, nope, the assets are gone. Don't own them, they're gone. But it tells the IRS, yep, I still own those because there were some tax benefits to hanging on to property until you pass away. And clients are like, wow, how do you do that? It's like, well, it's very technical, but that's what this trust does. We are telling two government entities two totally different things, and we're doing it completely legal, completely upstanding because their rules at looking at assets are completely different. All right. So typical MAPT features. Number one, it has to be obviously irrevocable, cannot be changed. I tell the client, the word irrevocable means it can't be changed. Well, we as attorneys are not going to make anything where it just absolutely can't be changed. It can be changed, but it's not easy. And so I always tell people it can't be changed, parentheses, easily. All right. But once you do it, don't expect us to change it. If we absolutely have to, we can, but don't go into it thinking, yeah, I'll just change this later. No, it is pretty much written in stone. The grantor absolutely, in all cases across the country, has no access to principal. If you've done this a while, and if you've done Medicaid and people bring their documents to you saying, hey, I know you're the Medicaid person, would you look at this and see if it's protected from Medicaid? I get irrevocable trust all the time from other attorneys who don't know what they're doing. And they're like, yep, here's your irrevocable trust that will protect you from Medicaid. And they bring it to me and I'm like, the grantor benefits from the trust principal. You're like, no, doesn't work. I'm sorry. No, but the attorney told me that. I said, I can't help that. I am telling you, this trust is not what you think it is because the grantor has access to the principal. If there's any way that grantor has access to the principal, it is not an MAPT. Okay. Now, sometimes in some states, my state that I don't do this, but in some states, it is okay for the grantor to have access to the income. Okay. So they many times will pay the income tax. I don't do that because typically my clients, we keep out just enough money to get them through the time period. And my clients don't want to pay the income tax on this anymore. So we shift that to the kids. But in some states, the grantor can still get access to the income. I know what federal law says. I know that having access to the income does not make you have access to the principal, but the state of Arkansas Medicaid has basically put down their foot and said, that's how we're going to read it, is if you have any access to this trust, it's a countable resource. I know we could fight it. I just don't want to be the one to fight it. Okay. And I probably don't do as many MAPTs as I could, because I'm very clear with the client, you're not going to get access to income from this trust. The trustee controls distributions, okay? And many times those distributions go to the kids. And one of the reasons people are okay with doing this is if they absolutely need money from this trust, the trustee, being a child, can pull money from the trust, give it to themselves, and then give the money to the parent. We don't want to do that consistently. We don't want to do it at all. But if we absolutely have to, we can sometimes to get through the 5-year look back. But that's why many times on the MAPT, you don't want a commercial trustee, because they may or may not give this money to the lifetime beneficiary. And if they won't give it to the lifetime beneficiary, then that's a huge problem. And so many times the trustee of the MAPT is a child who is also a lifetime beneficiary, can pull money and give it to the parents. Many times the reason for doing this is to hold the residents, and particularly some real estate that is not the home. That's the key thing. I'll go through this later, but the key thing that this trust does is hold that piece of property that the parents don't live in, that will always prevent them from qualifying for Medicaid. It's a family farm, it's a family vacation home, it's something that the family really wants to keep. And putting this into that trust gets it away from Medicaid so that these people can qualify, doing all of the other things we need to do for a crisis Medicaid case, but the vacation home, the farm, does not come into play. All right. And you can't put qualified assets into the MAPT. Obviously, you can't put them into any trust, but particularly this one. And many times that's what kills these cases, is having the vast majority of their $1 million or $2 million estate being in IRAs or 401ks. The tax hit to take those out quickly and put them into this trust to start the 5-year look back is devastating tax-wise, okay, and Medicare-wise. All right, so what an MAPT is not. It is not a cure-all, okay? It is not for every client. It is actually for very few clients. It is not risk-free. Okay, there are family issues. There are, drafting issues. If you do it incorrectly, that's a problem. It's not simple. Okay, I typically, and because it's not a simple trust, you have to make sure all of these pieces are in place together. I typically charge 1 month's worth of nursing home care. So whatever the nursing home is in your area, I think that's what you should be charging for this trust, because you are protecting not only the person, if it's a single person, yes, this trust will get this person onto Medicaid, but the real beauty in this is with a couple and you do this trust. If you understand Medicaid crisis, you understand we can get one spouse in a couple onto Medicaid with $1 million, $1.5 million by using the annuities and different things. But then if that second spouse goes in, they have $1.5 million. They're not going on Medicaid anytime soon. And so by doing this trust, this is the true benefit of this trust, is we're going to get both spouses in a much better position to get them onto Medicaid when they need care. So when one goes in, we get them down to an asset level that's easy to plan for one spouse. And now we have just a few $100,000 or $100,000 in the well spouse. And then when they go in, we're going to lose about 40 to 50% of that, but 40 to 50% of $100,000 or $200,000 or $300,000 is way less than 40 to 50% of 1.5 million. And so that's where this really comes into play. Is it's not simple, but it provides a great benefit. It is not fully protective. And what I mean by that is if it's not done correctly, it's not going to protect. If you do it correctly, what's in the trust is going to be protected from day one, basically. But you've just got to get through that 5-year look back. And a big thing that kills a lot of these plans is qualified money. All right. Why are these being over promoted? Well, they're expensive. You do generate a substantial amount of revenue from these. Okay. Time wise, it's a very high dollar proposal. And I surely hope that you're charging flat fees, not by the hour. These provide a tremendous benefit. They are expensive and they do generate significant income, but again, it's not for everybody. So marketing these tends to be kind of easy if you want to sell it to everybody. Okay, hey, we can protect you. Clients are basically afraid of this issue of going into the nursing home and losing everything. And if you play upon that fear, you could probably get some people to do this. And I see attorneys do that all the time where they're selling trusts that don't need to be sold. And when you're in a seminar, when you're doing a speaking event, it's very easy to overly simplify this to say, protect everything from the nursing home. Okay. Well, that sounds great until you actually can't do that. All right. And then going forward with this one size fits all thinking, stop that. Okay. Don't do it. It's not for everybody. Here's what I see is people think, okay, great. Everything that's in this trust is protected. So we'll just put everything into the trust. You transfer all the assets knowing, okay, the lifetime beneficiary can pull money from this trust and give it to me. And God forbid, if we need nursing home care within the next 5 years, we can just terminate this, give the money back to the parents, and it's, no harm, no foul. Okay, stick with me. If you put everything into this trust, there is no money to pay for care. And so you will have to undo the trust. Here's the problem with that, okay? And I don't think a lot of people think through this. And there's a prominent attorney in Arkansas, okay, has the certification to say he knows what he's doing, okay? Who seems to be, from what I've heard, putting everything into the trust. And with the thinking that if we need it, we'll just go get it. Here's the problem. Many states' rule is that to return a gift, if you're in a state that says, yes, you can return a partial gift, okay, if you give away money, if they give it back, we'll give you credit for that. So if you give away $100,000 and the kid you then get $50,000 back, well, the difference is $50,000. You only have a $50,000 gift, regardless of the 5-year look back. Those states, and some states require 100% to come back. But if you're in a partial return state and you're like, hey, I'll just get it back out of the trust, here's the problem. Those states that allow for a partial return many times will say, we will only give you credit if you get the money back from the person that the gift was given to. And I know Arkansas has dug their heels in on this, and I've done some things where money was given to the, quote, no good kid who smoked it or, spent it or did whatever. And some other kids like, hey, I'll give the money back. My brother's always taken everything, but I'll give the money back and that should undo the gift. Well, early in my career, I tried that. And I was like, hey, state, yeah, she made a $50,000 gift to this son. We've got $50,000 back. So we're, undo the penalty. And they're like, it only gets undone if that son gives it back. Uh-oh. Okay, so now you have an irrevocable trust that says the grantor is not the beneficiary of the principal. And by the trust definition, you can't give the money back to the grantor. But even if you did transfer money back to the grantor, the states that are very adamant that they're only going to give you credit for, okay, you gave it back, it has to come from the trust. And the trust says you can't do that. So the state's going to say, you can't do that. This trust clearly says the money can't go from the trust back to them. And so therefore, since it says that, we are not going to give you any credit for the gift. And when you put a $600,000 house into this trust and now you're giving it back, or you sold it and you have 600,000 and you want to give it back, but you can't. You've got to get through 5 years. I can't say this too many times. You have to keep out enough money to get through the 5 years, because following the terms of this trust, by law, you can't give the money back to the older person. Okay, Todd, we get it. Move on. Okay. So what other things can go wrong? Loss of flexibility and control. So many times when I'm presenting this, I tell my clients, you will have zero control of the money that's in this trust. It's a deal killer. And practice point, real quick, listen to me. When you're doing a meeting for these, I beg you, okay, to present it, tell it to them, and regardless of their response, and I'll go through that in just a second, if they're all for it or if they hate it, that means very little, honestly. Present it, tell them, and particularly for those that are all, yes, let's do it. That's the best thing I've ever heard of. Absolutely, let's do it. And I want you to think about it for 2 weeks. Okay, take this information. 2 weeks in the big scheme of things is not that long. I know you're excited to do it. I want you to think about it. Take this information, go home, talk to your family about it. I will schedule you to be back here in 2 weeks, and we're going to see if you're still excited. I promise you, half of those people that were super excited at the first meeting come back and they're like, yeah, I thought about it, and I don't think that's a good idea. Okay, what I just did is I've saved you a whole lot of heartache, because if, I charge $8,500 to do this trust, and I'm like, I want my money up front because I'm going to go do this trust. Had we signed a contract in that first meeting and said, okay, I'm going to go do the work, so you're going to pay me, and they pay the $8,500 and they come back to sign in 2 weeks, and they're like, yeah, I changed my mind on that. Okay, well, you could stand your ground, say, sorry, I did the work, I'm keeping your $8,500. Is that client going to be happy? No. Okay. Yes, you did everything legal, you did everything the way you were supposed to do, but that client's not happy, and that client's going to go mouth off to somebody. It's just not worth it. Okay. I've been there. Everything I do as a coach, an elder law coach, I tell people I've made that mistake. So I'm telling you from my own personal experience, let my bad decisions in the past help you now so that you don't make these bad decisions. I'm just telling you, don't take their money up front. Make them sit on it, have a cooling off period. And if they're still excited after 2 weeks, absolutely get their money and do it. And then if they change your mind, you can say, well, I gave you 2 weeks. You were excited. I gave you 2 weeks. You came back excited. What happened? But rarely does that happen. And I will tell you, those people who are like, nope, hate that idea. I don't want to lose control. I've worked hard to build this. I am not letting go of this. Give them 2 weeks. Say, I understand, but please understand what's in the trust is protected from Medicaid. That will go to your children. We're going to leave you out enough money to survive. And let's come back in 2 weeks and let's see what your position of it. Probably about half of those are like, I've slept on it and I think that's a good idea. I had one guy one time, he had about 1.8 to, somewhere around $2 million. And he hated the idea. And the kids were all there, and I think I even brought him back at the 2 week. He had told the kids, all the kids came back, and he still didn't like the idea. He's like, I just don't know. $2 million. I want the $2 million. And he was well up into his 70s. And the kids were like, Dad, why do you not like this idea? Why do you think you need to keep $2 million? And he said, well, I might want to travel. And the whole room just bust out laughing. All the kids were like, Dad, you haven't traveled in 20 years. You hate to spend the night away from home. What makes you think you're going to travel? And he's like, well, I might want to start. And they're like, Dad. Finally, by the end of the meeting, I truly don't think they beat him down. But at the end of it, he's like, yeah, you're right. And well, when I first asked him at the beginning, I said, okay, if we did this, how much just in contemplating this, how much would you think you would want to keep to be comfortable? And he said $2 million. And so that's when we got into it. It's like, Dad, come on. And so finally he thought, I think the number was 700,000. I said, okay, that's a lot of money, but based on 2 million, at least we're protecting 1.3. So it doesn't matter what their opinion is in that first meeting. They can love it or they can hate it. Coming back in 2 weeks, many times that changes. Okay, so loss of control is a big thing to people. They don't want to lose control. Number two, loss of liquidity. Okay, they don't have the liquid assets that are in the trust. You have to keep things that you don't want people to feel broke the last years of their life. Leave them some money, let them have some money. And if you leave them enough money to get through 5 years, that's what tells us this trust is not for someone with $400,000 or 500, even 600, because keeping out enough money to get through 5 years sometimes costs $300,000, $400,000, $500,000. And most people, if they go from 2 million or 3 million down to 500,000, psychologically it hurts, but they'll do it. It's like, okay, $500,000, I doubt I will spend $500,000 the rest of my life, knowing that everything that's in this trust will be protected. Okay, so you've got to help people make informed decisions. There are tax disadvantages, okay? Many times the income to the kids, if all of the kids are doing fairly well and they're in a high tax bracket, the income going from this trust to them is going to be taxed at a much higher rate than if it comes back to the parents. And in that situation, I don't want the income coming back, but you can make it so that the parent can pay the income tax, okay? That gets into the weeds. But your client needs to know there is no practical access to these assets. 2 words I shouldn't have used in the same sentence. There is no access. I just tell people you have no access. If it just comes to an absolute emergency, yes, we can get some money from here to your kid and from your kid to you. But we don't want to do that very often because we don't want Medicaid saying, where's this money coming from? Where did this deposit come from? And particularly if it happens, consistently. A friend of mine called me, I think 2 weeks ago and said, hey, Todd, I have no answer, but I just wanted to run this by you. We did a MAPT for this family and she apparently ran out of money. And so they had the investments in the MAPT pay out directly to her bank account each month. Directly from the trust to her. The family did not call the attorney, did not run it by them. Now she's going into the nursing home and they're like, hey, we're past 5 years, mom's going to the nursing home. And he gets to looking at it and seeing this transfer. And he's like, is that going directly from the trust to her? And they're like, yeah. Why didn't you call me? It's like, well, we thought we probably should have called you. Yeah, you really should have called me because now, and I don't know how it's going to turn out, but it's not going to be pretty. Okay, so there is no access to the assets. And if you put all the money in the trust, there is no money to pay for care. Your true role as an elder law attorney, your true role is to solve the client's problem, not just get rid of assets. Okay, they come to us for a solution. We understand this way better than they do. And it's our job to come up with a plan. And sometimes the MAPT works, but also consider partial MAT. That's my recommendation. If you do any MAPT, you do a partial MAPT. But if you have those clients who come in who have, they're in the $400,000, $500,000, $600,000 range, where keeping out enough to get through 5 years leaves very little to go into the trust. And so at that point, I tell people, look, there is nothing we need to do right now. We can spend down at that point. Okay, if you need to spend down now, go pay off your house, buy a new house, do something. We can spend down now or we can do it later. Insurance, long-term care insurance is so much better nowadays. There are some really cool plans out there that even people with diagnosis can double or triple their money. They can put $200,000 in this product and it will at least pay $400,000, and with the right not having particular diagnosis, it may triple. We can have $600,000 worth of benefit from a $200,000 investment. And so if you're not comfortable talking about long-term care insurance, call me. I'll be glad to. licensed in all 50 states, or can be if I need to. I can discuss that. Amber is really good at this. She understands this. Give us a call. Let us help you and your client walk through this, and maybe there is an insurance solution as opposed to the MAPT. There's gifting, there's annuities, and sometimes no planning at all at this point, but you're putting that client on the back burner and they will call you when they need care. And so, yes, you're not getting money today, but just kind of think of it as a much better investment later on. The ideal MAPT, health and planning time. You have healthy adults with the long horizon, ideally way more than 5 years. And we don't know what the future holds. I've had really healthy clients go down quickly, be in a car wreck, things happen. But if you're sitting here and they don't have a substantial amount of diagnosis, or they're early in their Alzheimer's, you probably have 5 years. That's a good client. They also need to have sufficient assets. Again, not $300,000, $400,000, $500,000. They need enough money to keep out enough to get through 5 years and enough to fund the trust. And then you need people who, if they meet the first two, they're okay with losing control for the advantage of leaving a legacy for their family, saying what's in this trust is going to be protected. And once you tell people that, it's like, I know you want to hang on to all of your money, but if you need nursing home care at $9,000, $10,000, $12,000, $15,000 per month, wouldn't it be nice knowing that someone else is paying the bill? We took the legal actions that we could to protect this money. So married couple, 68, 70, $2.5 million estate. They have a strong income. They're healthy and they have a good family. And they have concerns about nursing home costs. I think this is presumed. If you're just an estate planning attorney, I hope that you bring up long-term care in every meeting, because it's a huge issue. If they're over, I would say 50, your 40-year-olds are like, nah, don't care. I'm not worried about it. But if they're over 50, they've probably had some friends or families that have had parents go through this, and they at least have been exposed to it. If they're 60 or 70, they are concerned about it. And many times they don't know that you're the person that can help them deal with this. They don't think of long-term care as being a topic that they bring up with their estate planning attorney. I encourage you, as an estate planning attorney, bring this up to people and say, what's your plan for long-term care? And if at least bring it up, make a note that you brought it up. Sometimes they're receptive, sometimes they're not, but at least you brought it up, you introduced it to them and gave them that opportunity. All right. A really nice thing is if you have appreciating assets. Here in Northwest Arkansas, real estate, man, even the rural real estate that has stayed low for years and years and years is now becoming, trust me, I just bought 30 acres. I understand that. It is going up in value, and that is an appreciating asset that if you can get it away from the Medicaid countable assets, and even if it's your home, okay, even the home, which is a non-countable asset, but Medicaid can put a lien on it. And many times the family wants to sell it once the occupants, mom and dad, go to the nursing home. They're like, we don't want to keep this, we want to sell it. Well, if you sell it, all the money goes to the parents. And so it's a really good selling point to say, look, let's get this out of your name now while it's at the current price, probably lower than it's going to be in 5 or 10 years. Let's let the appreciation grow and the kids benefit from that, rather than penalizing you and keeping you from ever getting onto Medicaid. So future appreciation occurs outside of the Medicaid estate, the estate for Medicaid, but they still get a step up in basis because this is a grantor trust. It's a beautiful tool. Now, residence, I just went through that. Okay, primary residence, even, you absolutely want to put other real estate, non-home real estate into the trust, but many times you should put your home because of the sale and the increase in value, and to avoid the Medicaid lien. All right. So again, it can be sold without issue to the grantors. Poor candidates, imminent care needed, okay? Now, just because someone's going into the nursing home doesn't mean you can't do an MAPT. Listen to me. If they're very wealthy, okay, single person with $3, $4, $5 million, problem is typically that's going to be an IRA, okay? It's going to be qualified money and the tax hit's just not going to be worth the benefit that you get from Medicaid. But if you get the rare instance where it is non-qualified money, we can transfer it out and to the trust, we now only have to pay for 5 years. With $2, $3 million, they're going to pay until that person passes away, regardless of how long they live. But with the MAPT, you tell the family, hey, we are stopping the bleeding at 60 months. You're going to pay for these 60 months, and there's no way I can prevent that. Without this trust, you're going to pay the rest of their life. But with this trust, we know in the 61st month, hey, Medicaid, we're broke and we've made no transfers during the previous 60 months. He goes on to Medicaid. Yeah, 5 years is going to be expensive, but it's way less expensive than the rest of his life, potentially. Poor candidate, not enough assets, okay? There's just not enough to keep, if you go by the rule of keeping out enough to get through 5 years, you have to have quite a bit of assets for this to make sense. Family issues, okay? Who's going to be the trustee of this? It's going to be one of your kids. Well, my kids hate each other. Okay, that's a problem, okay? Honestly, if they hate each other, there's a concern. They may not be fair, even though the law says you have a fiduciary duty and blah, blah, blah. But if they hate each other, this is going, and absolutely, you don't want to do co-trustees. Sometimes I have recommended to not do the MAPT when everything else looks beautiful. This is the perfect solution for your family, but your kids don't get along. Then sometimes it's just not right, okay? Again, here's some alternatives to the MAPT, partial MAPT, okay? If you do one, it should be partial. Spend down, gifting, annuities, insurance. You have to evaluate this on a case-by-case basis. It is very fact specific. Don't be an MAPT machine. Be the client's problem solver and trusted counselor. I am coaching a person right now whose boss doesn't do elder law, is just trying to fund the company. And he is on her case constantly. We need to do more MAPTs, do more MAPTs. Why aren't you doing MAPTs for more people? And thankfully, she's listening to me because she doesn't want a malpractice claim and saying this is not for everybody. But as the owner of a business and you want to increase your bottom line, sure, you want to do more MAPTs, but it's just not worth the hassle. It's not worth the clients being upset. It's not, 3 years into this, they come back to you and say, mom's in the nursing home and we have no money. And the MAPT can't go back to mom. What do we do? And you're like, I don't know. You just got to get through 5 years. Not a good conversation, okay? So your role as a counselor, I always thought it was interesting as I was going through law school, you're attorney at law, esquire, and then sometimes counselor of law. And I thought, counselor of law, that's weird. When you're doing someone's divorce, you're just working as a lawyer. It was when I became an elder law attorney that I was like, I'm a counselor, probably more than I'm a lawyer. There are a lot of things I am counseling clients and families on that really are not that legal based, but it's just my understanding of Medicaid and how things work. I can give them good counsel because of my background. Tailor planning to each client's specific needs. Every fact pattern is different. That's why I love elder law. It's a different case every time, even though 90% of the facts may be the same. She has dementia, she's old, she's going to the nursing home. We have a house, we have annuities, we have investments. It's a lot similar, but that 10% makes it really interesting. And that's what makes your value as an elder law attorney who truly understands what you're doing, okay? Professional responsibility, solve, don't just sell. My staff still this morning was on my case. Last week, I turned down $12,000 worth of fees. okay? One was an MAPT. He came in, his attorney told him he needed an irrevocable trust. The research he did on the internet said he needed an irrevocable trust. He came into me absolutely willing to write the check for an MAPT. And I said, once I went through the facts, I'm like, you don't need one. And there were, I won't go into it, but he did not need one. And so I was like, there's $8,500 out the door. The very next meeting, client came in with their trust, said, I need to completely redo the trust. I don't trust the attorney who wrote this. I want you to completely redo the trust. I'm like, tell me about your kids. And we have 2 kids. Any issues? Nope, they're absolutely good with money. I have no concerns whatsoever. Them getting the money, they get along great. I have no concerns. I just want the money to go to them. They can use it as they want. And I'm like, I can do it. I can redo your trust and put it into testamentary trust so that the kids' money is protected. He said, I'm not concerned about that. And I said, look, payable on death. Don't redo your trust. Let's just kill the trust. Let's get your home from the trust back to you. Beneficiary deed avoids probate. Bank accounts payable on death avoids probate. I said, you don't need a trust. There's $3,500. What's that? $12,000. Okay. $12,000. Poof, gone. But I sleep good at night. And Monday night, I ran into a client at Lowe's because I'm building chicken houses. And I recognized him. He said, hey, you're Todd Whatley, aren't you? I said, yeah. And he said, hey, Dad's in the nursing home. Dad's doing great. Thank you so much for what you did. I have what I call the Walmart rule. I live in Bentonville. Walmart's everywhere. Walmart is huge. I have what I call the Walmart rule is I may not know what I did for clients, but I know if I run into them at Walmart, I'm not ashamed. Okay. It's like, I forget what I did for you, but I'm pretty sure we did exactly what was in your best interest. And I don't have to worry about that. I don't have to worry about selling something to someone that turned out to be bad or did not meet their needs. And walking at, pushing $12,000 back across the table to say, nope, hurts. It honestly hurts. Okay. But I sleep well at night. And those, particularly the $8,500 guy, he's like, oh my God, I know a lot of people who need you, and I will absolutely go tell them about you. I'll make that $8,500 back in multiples from other people, but just not that client. Okay. Go with me. If you want to truly understand trust, if you want to, not just the MAPT, but charitable remainder trust, grantor retained trusts, spousal lifetime access trusts, irrevocable life insurance trust, all the really, really high level complex estate planning, I encourage you to come to the Estate Planning Transformation Weekend. It's June 12th through the 14th. It's getting close. We're about to shut this down, but there is still room. If you want to truly, truly understand estate planning and spend 3 days with me, okay, we're going to lock ourselves in a room and we're going to learn this stuff extremely well. It's all day Friday, it's all day Saturday, and it's more than half a day on Saturday. We're going to go through this hours. And when I say all day, I mean 8 or 9 hours. We're going to push through and you're going to know this stuff extremely well. If you truly want to transform your practice, I encourage you, email Tricia@theolderlawcoach.com and schedule a phone call with me. Let's talk, or just sign up. It's going to be really good. Come in with a select few other attorneys, and we're going to sit down and we're going to learn estate planning and a little bit of Medicaid, because I think all estate planning attorneys need to understand Medicaid also. And so come join me June 12th through the 14th. It's beautiful here. It's not hot yet. Bentonville, Arkansas is absolutely beautiful. One of the top vacation destinations in the country. Come see me. Questions?
Thank you, Todd. We do have a handful of questions here. So the first one is, what do you recommend for the farm owner that wants to protect the farm but needs or wants to keep the income? I see the retention of trust income in the MAPT as a bad idea and basically picking a fight with the Medicaid caseworker.
Yep. So you increase the amount that you keep out of the trust is what I would do. In some states, giving the grantor access to income is not an issue. And Amber can possibly answer that for you. I can look it up, but in a lot of states, any access to the trust is a problem. So the other answer is, well, it's a continuation of the answer. IRAs don't go into the MAPT. So many times I tell people, look, we can't put this in there. This is what you live off of. And the financial advisor gets all panicky because it's like, oh, you're dipping into your IRA. Yeah, I'm dipping into my, shut up, it's my money, I'm going to get into it. Because I'm protecting all this other money, my home and all my other assets are in this trust, it's going to be protected. Yes, I'm going to dip into my 401k and live off of that money. And then they take the money periodically at a much less tax break or tax hit, and you need to fully understand how the income tax works and the areas. So, you know, a single person can make, I think, 150 and still be in the 22% tax bracket. A couple can be way on up there and still be in a 22% tax bracket. So pulling from the IRAs, we're all taught, don't pull from your IRA. But at this point, the plan is we're going to protect everything else and we're going to start living off of the IRA.
Okay. There's a question about how do you advertise your MAPT?
Well, it's just part of the plan that I do. It's with estate planning. It's like, there is a tool that can help you. It's not for everybody, but please come see us. And if this doesn't fit, if it does fit you, fantastic, let's do it. But if it doesn't fit you, my knowledge of Medicaid will help you understand there are other options. Insurance, there's do nothing and let's just spend down later. Go buy some things. People are so nervous. Oh, should I buy the boat? Heck yeah, go buy the boat. Okay, go buy the boat. We'll take care of it later. It'll decrease in value after you buy it. And then that's not such a problem. You know, take the kids to Disney World. Okay, people are so worried about gifting. Oh, I can't make gifts because of the 5-year-old. Make gifts, okay? Go do stuff, enjoy your money. My rule is on gifting is keep back as much as you give away, because if you understand crisis Medicaid, we can almost always protect half. And so if you come into me with $200,000, I'm gonna say, give away 100 and we're gonna use 100 to pay for the penalty. But if you come into me with 100 and you've given away 100, that's okay. We have 100 to take care of that gift. So if you want to maybe go with the kids to Disney World, and a lot of older people are like, no, not going to Disney World, but I'll be glad to pay for them to go and they can send me pictures. Do it. Do something. It opens up people's avenues to really do what they want to do. So yes, so I mention it that way. It's like, yes, there's this tool that could be really cool. It may work for you, but if it doesn't, I have alternatives.
Okay. Can you explain what you mean by a partial MAPT?
Yeah, partial is don't put everything into the trust, okay? I mean, part of the asset goes in and part of the assets don't go in.
Okay. There's another question here about the cost of your training. Is that something that they should reach out to Trish for?
Yeah, I think that weekend is, don't hold me to this, I think I'm close, is $26.95.
Okay. We have a question here about this attorney puts everything other than retirement assets into the MAPT and tells clients to make distributions to the children or to the beneficiaries, who then pay the nursing home bills out of pocket until the 5-year look back period is over, instead of holding money back. If there are retirement accounts, we tell them to leave enough in those accounts to get through the 5 years. Is this a mistake?
I like the person's own IRAs, getting them through there. I mean, yes, you can do that. My concern is Medicaid gets real funny when, where's this money coming from? Why is someone else paying their nursing home bill? Medicaid has in the past gotten very nosy. And I don't think it's their right to ask that, but if they, all they've got to do is say, yeah, we don't like this, we're denying it, and then you're in the appeal process, and that can take 2 years. And I don't like having the money come from the trust, absolutely not directly, but even in that roundabout way, I try to do it in periodic payments if we need to, so it's not so consistent and it doesn't throw up red flags at Medicaid. But my fear would be if someone else is just paying for that care, it's going to be a concern.
Okay. And then there's another question here about, I didn't understand your comment about the residence and the MAPT being sold without any issues. What does that mean? I thought that the parents were still living in the home and that's inside the MAPT. Do you provide a life estate or a rental agreement is the question.
Okay, so that comes up when the parents leave the home. Okay, they're now going to the nursing home. They're either within the 5 years or even after the 5 years. And yes, we do give them the right to live there as the rest of their life or as long as they're able to live there. But once they leave the home, then many times the family's like, I don't want to keep this. Insuring an empty property is very expensive. I don't want to do this. And so they sell it. If you had not put it into the MAPT, the sale of that home, the money goes back to the parents, causes them to be disqualified, or gives them more money that you can only protect half of. That's the problem. Selling it within the MAPT is not a problem in that transfer occurred when the deed went into the trust. Selling the home 2 years, 3 years, 10 years later doesn't matter. It's the trust that sells it. That money stays in the trust and does not go back to the grantors.
Okay. Do you ever use a MAPT in a crisis Medicaid scenario with a single person who's making a large gift and then holding some of the money back to do like a Medicaid SPIA or a promissory note?
Yes.
Okay.
Yep. Many times that's when there's multiple family members, or it's just not a good idea to give the money outright. Yes, I will use it in a crisis mode, but we need enough money to get through those 5 years.
Okay. An issue that this attorney has is adult child who is a lifetime income beneficiary of the MAPT has soon to be college age kids. Does the status of the MAPT lifetime beneficiary impact a FAFSA application for future college age kids?
I would assume so, yes.
Okay. And then the final question was just asking about the insurance products that you mentioned to leverage assets. And our June webinar is actually talking about some of the products that Todd mentioned with the guaranteed issue, long-term care policies, and then pre-planning policies, the hybrid long-term care. So if you're interested in that, you'll be able to sign up on our website after today.
Good.
So one more question here. Do you file the MAPT on the social security number or use the EIN number?
I typically use an EIN.
Okay. I think that was
just for the trust, yeah.
Okay. That was the last question that I see, but I assume if people have more questions, they can email Trisha using the email address that you had provided. I want to thank you, Todd, for a great presentation. We got great feedback here in the comment section, and thank everybody else for joining us today. Take care.